everyone, and welcome to today's webinar, sponsored by the Legislative Staff Coordinating Committee and the National Conference of State Legislatures, the Forum for America's Ideas. We're honored to have so many people joining us from across the nation for the second part in our two-part series on social media. The first part in our NCSL University series went over the trends and communication strategies of social media for state legislatures and state legislators. That session is archived and available on the NCSL website and is free for state legislators and legislative staff to download. Today we have three experts with us who will guide us through the policies, legal aspects, and ethics of social media use in state legislatures. With us today is John Heine, who serves as General Counsel for the Texas Legislative Council, providing legal support for administrative, contractual, and personnel issues. And he's joined by Pam Greenberg, a Senior Fellow at NCSL, who tracks information, technology issues for NCSL and staffs the NAILIT staff section, and her colleague Natalie O'Donnell Wood, a program principal with the Center for Ethics and Government at NCSL, who conducts training on ethics and lobbying issues. Our agenda for today is on the screen. Our presenters will offer their observations for about 40 minutes, and the rest of the hour will be spent taking your questions. You may drop a question into the box at the lower right-hand side of your screen at any time during the presentation by using that chat box icon. So let's get started today with social media and state legislatures. For that, I will turn the microphone over to Pam Greenberg. Pam?
Thanks, Gene. So when I first created this slide, I remembered when I first started researching social media issues and was tracking legislative social media sites. And I read everything that I could get my hands on about legal considerations and privacy and security issues, and basically got overwhelmed. And so sometimes I wondered why anybody would use social media. But then we had an NCSL session, and Rick Cantrell, who is Chief of Staff at the Utah State Senate, he spoke about why and how he uses social media. And he's really a trailblazer in this area for legislatures, I think, and he described really with a lot of passion and eloquence about how it can help create trust in government and make people feel like they're a part of the process. And you can even see this perspective on their website. So Rick really sold me, and I'm hoping that after hearing about all these issues today that you'll still think that using social media is worth it for these kinds of reasons. So I know that many of you listening are responsible for social media sites and have lots of expertise in this area. We've tried to keep track of everybody and all of the social media sites since around 2008 or 2009 by searching and reviewing websites. And I've seen a big increase in the use of social media over the past 3 years, both by caucuses and by nonpartisan sites, nonpartisan offices. And as you can see, there are more caucuses that use Facebook and more nonpartisan offices that use Twitter. And so I think intuitively that makes sense. It's the nonpartisan offices in particular seem to be using it as a reporting tool lately to report on actions or committee hearings that are happening, those kinds of things. You can find our current list of and links to social media sites on our website. If you enter go and then a space and then 13409 in that white search box in the upper right corner of our site, you can pull up that page. So if your office doesn't have a social media policy, you're not alone. And there are some people who think that they're not needed. But I personally disagree with this quote because I think social media is both weird and magical. And while you might not need a standalone social media policy, you probably want to consider or re-examine your existing personnel policies or acceptable internet use policies, those kinds of things, because there are unique circumstances that can arise with social media. And also there are a lot of good guidelines and good examples out there now that you can follow. And we'll be talking about some of those. And again, if you enter Go 18215 in the white search box, you can pull up another web page at NCSL that's keeping track of or providing some examples of legislative policies and other organizations' guidelines. So what kinds of policies should you have? I like to think about it in terms of, first of all, you look at policies that address the public's use of your site. And, I know one of the biggest concerns people have is how do they handle comments from the public. Generally speaking, because of First Amendment protections, a government needs to be very careful about deleting comments. And I'm going to mention that I'm not a lawyer at this point, but generally, if you do have a policy and you're clear about the purpose of your site and you tell visitors your policy, it's still a risky proposition, and it depends on what jurisdiction you're in. But you can take some examples from this slide from, for example, the Texas Legislative Council that describes what their policy is. That's just an excerpt also from the NOAA site, but sometimes I think people don't realize that you can't delete or just black out a profanity, that in a lot of these social media sites that the whole comment needs to be deleted if someone's going to do that. Again, it's a risky proposition. We'll talk more about that later, I think. Another issue that's important to address for the people who use your site is to tell them what might happen to information that they post on your site. And here's just a couple of examples of how a couple of different states have handled that issue. And then one of the easiest policy set, or actually maybe it's not that easy, but it's a decision about whether employees can use social media during work hours. And there are a lot of different approaches to this in legislatures, as you can see, from blocking or prohibiting it entirely on your network to allowing for some discretionary personal use of social media. But it gets a lot more difficult and complicated when you look at employees' use of social media on their own time. Some employers have told their employees that they can't post disparaging comments about their company, or that they should not say where they work on a personal blog or Twitter account. But rather than go into the specific and complex legal issues here, I thought I would just make 2 points. First of all, if you're an employer, be careful about what you tell your employees as to what they can or can't say. And then secondly, if you're an employee, if you say something inflammatory or obnoxious, you could get fired. So Jeff Cox, he never identified himself as an employee of the Indiana Attorney General's office. And apparently he was known for sort of being sarcastic and satirical. But the comment that got him fired was a tweet where he said that live ammunition should be used on protesters at the Wisconsin Capitol. And, of course, he said he was kidding, but the AG's office said that he was fired for violating the employee handbook. And that handbook said that employees should conduct themselves in a professional manner during and after working hours. The AG's office also said that they didn't have a social media policy, but that they were working on one. So one good resource for information about these kinds of policies is a recent National Labor Relations Board report, and that gives some real cases and provides some guidelines about policies. We'll have a slide with the name and a link to that report later on. But again, it's a tricky area. So now that we've talked about personal use in the workplace and personal use outside of the workplace, we can also think about professional use. You're representing your own organization in the workplace. So lots of social media policies warn against using copyrighted materials or trademarks, and that seems pretty straightforward. But this, I thought, was a great example about how easily a rule like that could be overlooked or not recognized. This graphic was posted on Florida Governor Rick Scott's Facebook page by staff, and it was actually staff who were from a company that was hired to manage all of his social network accounts. If you notice the headline on the right, they grabbed the image of the Herald's front page, and and then they cut and pasted in their own made-up headline. I guess a blogger discovered it, partly because the date line on that was Guatemala, which doesn't really fit in with Florida. But after that, you saw headlines like Governor Scott's team invents good news, and Governor's Facebook page makes up headlines. So, but even worse is that the Miami Herald was not at all happy with this, and they told them that it was a trademark infringement for using their masthead in a fake edition, but it's also a copyright infringement for using portions of the front page that were real. So another tricky area for governments using social media relates to public records laws. And I'm not aware of any state laws that specifically mention social media, although there have been some bills, a South Carolina bill this year. But state laws generally vary quite a bit. Many of them will mention electronic communications, or they'll say that it's the content and not the format of a record that determines whether it's subject to disclosure. So depending on the laws in your state, you could be asked to produce your social media postings through a public records request. And then similarly, with open meetings laws, they vary, but if government officials are discussing public business among themselves and there's an immediacy to their comments and responses, like using chat, then it could be considered a public meeting. And I think John's going to talk a little bit more about that very shortly here. So with records retention issues, retaining public records, laws and policies in the states, again, vary quite a bit. And also just the sheer volume of social media postings and the immediacy of it can make it seem harder to retain these kinds of records than other types. I think people are still trying to get a grasp on how to retain email, not much less social media postings. But there are now a number of tools that are built into Facebook and social media sites, but also there's software and other kinds of tools to help with record retention. So now I'm just going to turn it over to John, and he has sort of the real in the trenches experience and the legal expertise about these issues. So, John?
Hi, Pam. Thanks very much. I appreciate it. Yeah, actually, I completely agree with what you were saying, and I think a lot of the problem that we as attorneys face when we're dealing with developing these types of policies is it's extremely difficult to put these together because, first of all, the statutes that apply to social media or potentially apply to social media have not been updated recently in order to really reflect what's going on out there, understandably, because the social media is such a young technology. And moreover, social media is just really not designed to support the needs of government in a lot of ways. And so I'll give you a couple of examples here. If you look at our Texas's legislative advertising statute, it basically says that if you're getting paid to support or oppose a measure that's before the Texas legislature, you have to disclose this. It's very simple. You just put, paid advertisement on behalf of so-and-so, that type of thing. And it was last amended in 1991, and it was obviously intended to address people making bumper stickers or making pins and that type of thing for supporting or opposing measures. Well, nobody really makes pins or bumper stickers anymore. They're all on Facebook and Twitter and a variety of other social media outlets there. And the problem here, though, is that let's say you are a legislative staffer and you like your boss's bill. So you're tweeting about how you like it, or you're tweeting about how you're opposing some other measure that your boss doesn't like. Let's also say that you're getting paid to do your job. Well, I think it's entirely possible. I think it's entirely reasonable that this legislative advertising statute that was last updated in the time of Prodigy and AOL applies to your behavior there. And so it's a real concern. Should it apply? Well, I don't know. Probably not, but I don't really know what the intent of the legislature was at that time. Similarly, let's say you're a staffer that splits your time between the political campaign and the legislative office. It's extremely easy to switch between your roles, especially when you've got your iPhone sitting in front of you, or your BlackBerry or whatever, to switch between your roles of political advertising, where you might be engaging in political advertising on behalf of your boss who is in the middle of a campaign, and your job there at the Capitol, where you might be doing more mundane things, just supporting the legislature. So if we move on to the next slide there, another issue is records retention. The State Archives Commission here in Texas has determined that electronic media is not of archival quality. So anything that you produce in your capacity, again, we have a functional definition of records that need to be maintained in accordance with our archives requirements there. Let's say you have a Facebook or a Twitter account which is you're using to support your official function there. I think it's pretty clear that our State Archives Commission is going to require you to print out every single one of those documents. And similarly, those documents are all subject to archival review potentially. And there's really no promise by Facebook or any of these entities that they're going to maintain these documents forever. So at some point, it might be necessary to print out these documents and keep them in a drawer somewhere. It's really difficult to know where you're supposed to go from there. If we go to our next slide. Another issue is public information. If you have a request, if somebody makes a request where there might be responsive information on, say, Facebook, and I've actually had to do this once, where I had to search through 6 or 7 years of Facebook postings trying to find a responsive posting on a Facebook account because we were pretty sure that something like that existed. That's extremely difficult. Imagine just paging through Facebook pages over and over and over again, just trying to find something that might be responsive to a particular Public Information Act request. And that, again, goes to that content-based definition that is in our Public Information Act. So we move to the next slide. And the next issue that we might deal with is open meetings. We need to be very careful, especially if the Open Meetings Act in Texas doesn't actually apply to the legislature. So we have a tremendous luxury there. But if it does, it's extremely easy, again, while we're on, say, Facebook or Twitter, to discuss the issues that are before a particular body to which the Open Meetings Act of a jurisdiction might apply. And if, at least in most jurisdictions, what ends up happening is if a quorum of the membership of a body discusses some issue before that body, that's what's called a walking quorum. If it's done electronically, or you have people that are doing it on your behalf as well. So, and that can have criminal repercussions, and it can also have civil repercussions. So let's move to the next slide. Another issue that we really need to be concerned about is defamation. The mere act of causing something to appear on the internet is publishing from the standpoint of defamation. And let's say you wake up the next morning after you flame somebody on the internet, and you decide, hey, that really wasn't that great of an idea, so I'm going to go ahead and delete that message. Well, you have still committed the tort of defamation, so you might be able to perhaps reduce the damages that are going to be awarded against you. But if you are found liable for defamation, that can still take place because you committed that act in the first place. The other issue to really consider here is that oftentimes the winning a judgment is not the goal. They're just trying to get you to hire an attorney, which can be expensive, and potentially try you in the media. Another issue to consider as well is that just because you said something that was true, that doesn't mean that it's a defense. In California, there's a tort called public disclosure of private facts. Because of the very dispersed nature of the internet and therefore social media, it's possible anyway that somebody could obtain jurisdiction in a jurisdiction like California and then sue you based on one of these torts, and that's called libel tourism. And again, maybe they can obtain jurisdiction. Maybe you just have to appear in a foreign jurisdiction, let's say California. Maybe it's a nice trip for you to go out to Sacramento or whatever, but it's definitely going to be expensive. So let's move to the next slide. Another issue to consider is how ethics organizations are treating your activities on social media. This is an opinion from the Judicial Ethics Commission in Florida from 2009, and they said that lawyers who appear in a judge's court can't be friends on Facebook because that indicates a special position of influence with the judge. Now, of course, you can be a fan because that doesn't indicate that same sort of special position. And now Facebook doesn't have fans anymore. You can like them. And, of course, you can still contribute to their judicial campaigns. That doesn't indicate any sort of special position of influence. And my point here is that regardless of the logic of this opinion here, the fact is that we as legislative employees need to be aware of these types of decisions and make sure that we're conforming to them to avoid trouble. Let's move to the next slide. Another issue here is employers in being friends with their employees on Facebook. There's a growing trend of employers requiring employees to provide logins and passwords to social media accounts so that they can go in and find potential issues. And it's understandable. For example, you might be just trying to verify the resume. Did you actually go to school at the school that you're claiming? Have you previously poor-mouthed an employer? So if I end up firing you, you're going to rake me over the coals. Do you take photographs of yourself engaging in lewd behavior? Just the mere fact that such a photograph exists on the internet might indicate a lack of discretion that would make your employment, especially in the legislative environment, problematic. These are all understandable goals for why an employer wants to get involved in that. However, the problem is that while you might find those things out, you almost certainly will find out whether that person is in one of the protected classes that I've listed there. And let's say that applicant doesn't get that job, and they know that you know that they are of a particular religion or in some jurisdictions a particular sexual orientation, they can certainly sue you. And again, maybe they're not going to win, but they can at the very least force you to appear before the EEOC or at least hire an attorney. Again, this can be problematic. Let's move on to our next slide. Another issue that that has just recently come up, our members here at the Texas Legislature are all, a large percentage of them are early adopters. They all bought iPads for the 2011 legislative session, and they were using them on the floor in a really neat way. They were uploading their bill books using Dropbox or Box.net. I think it's called Box now, or iCloud, whatever. And that was how they were conducting their business on the floor. It was a really neat solution and really exciting to see that happen. So I'm one of those nerds who actually goes and reads the use policies that are available for these services here, and I noticed that Dropbox actually asserted copyright over all of the documents that you uploaded to them. Obviously, that is not in line with the expected use model of the people who were in the legislature who were using those things. And so, it was a significant concern for me. Now, Dropbox has since changed their policy on this issue and no longer asserts copyright over documents that are uploaded. But that's definitely something that you need to be aware of, is that you're comfortable with those terms and conditions. Understand that YouTube and Facebook have both adopted terms and conditions that make it much easier for state governments to use their services. I encourage you to look at that and investigate that if that's an issue that you're interested in. Another issue that I'm concerned about is, let's say you have a member who is involved in a piece of legislation and then is sued based on that piece of legislation. And they are trying to be, and an attorney is attempting to subpoena their records. Well, if those records are the product of legislative work by that legislator, I think there's a strong argument that it's going to be legislatively privileged. But if Dropbox or iCloud or Box don't actually assert that privilege and just turn those documents over because a legal subpoena has been served to them, that's not really helping anybody. So, I called all of these operators here and asked them, hey, what is your policy? Are you going to at least notify the individual member or notify the user that there's a subpoena of their records? What are your procedures there? I have received absolutely no response with regard to that issue. So something to be concerned about, something to think about as we start using these cloud drives there to access our documents. One final issue on this is, who has your passwords? If you have an employee who is responsible for putting these documents on the cloud so that you have access to them on your iPad, make sure that employee isn't backpacking in Nepal when you need to have access to those documents. Make sure that you have access to those passwords and that they don't leave with the individual employee. Let's go to the next slide. Another issue, I touched on this before, is the commingling of resources. If you're doing political work on your state-provided iPad or iPhone or BlackBerry, at least in Texas, there's no de minimis exception for that. That's absolutely not allowed. Furthermore, it's so easy to do. You're sitting in your office and you decide that you want to use it for a personal reason or a campaign reason, and you just happen to be in the Capitol when you're doing that. That may not be appropriate in the particular jurisdiction where you're operating, and you should really consider that. Another issue is that, again, it's so easy to start working on the campaign, and time is a thing of value, at least in the state of Texas. And so we have to be very concerned about making sure that you're not doing work for personal work or campaign work while you're working where you should be working with the state while the state is paying you. So let's move on to the next slide. Now, something else to consider as well is confidentiality. We want to make sure and protect the confidentiality of constituents. I've seen constituents post very, very personal information, protected information, on state officer Facebook accounts. Just because they're doing it doesn't mean that we should, or that it's legal to do that. Similarly, if you obtained information through that is protected or subject to a special confidentiality statute, rule, or policy, make sure that you're aware of it. Again, these social media sites are so accessible, they're so easy to get to, that sometimes it's very easy to share things that we shouldn't be sharing, and are potentially illegal to do so. And then, of course, misuse of official information, at least in Texas, that's a Class C misdemeanor. So let's move on to the next slide. On top of these statutory confidentiality obligations, one thing that we really need to be concerned about as well is just sometimes we're not even sure what types of confidences we're keeping. In this example here, apparently Senator Claire McCaskill from Missouri, she's a very avid tweeter, and she was at one of the Senate cafeterias there, and she saw Senator Bennett across the floor talking to some journalists and tweeted that. And, of course, she dropped this little joke there. We all have complex relationships with the media. Don't know whether to say congratulations or save him. So, just cute little thing. She's just observing what she's seeing there in the cafeteria. The problem was that David Sirota, the guy in the middle there, was a journalist, and he was actually trying to get in touch with Senator Bennett and get an interview with Senator Bennett. And Senator Bennett had apparently been telling him for weeks, oh, no, I'm not talking to any journalists. After this very important vote that's coming up in a few weeks here, I'll be taking interviews and I'll be doing that type of thing. But I'm not talking to anybody. Well, so Senator McCaskill basically showed him announced his lie to the entire world. David Sirota, who had been following Senator McCaskill, noticed this and wrote a really nasty article about Senator Bennett just a couple of days later. So my point being here is I don't think Senator McCaskill was trying to out Senator Bennett on this issue here, but I don't think she had any idea that she had probably breached what Senator Bennett was trying to keep confidential there, and we need to be concerned about those types of issues when we are engaging in activities with social media. And so speaking of those types of issues where maybe it's not illegal, but we should be sensitive to them regardless, I think Natalie has some things to bring up about that.
Thank you, John, and thanks everybody for being with us today. Hopefully you like this slide. The hardest part about doing one of these webinars is I can't read the room, so hopefully I'm getting some courtesy laughs out there because I thought this was funny. Do we know someone like this? Are we someone like this? Well, hopefully not. But I think it sort of speaks to how integrated the use of social media is and how the line is blurring between the personal and the professional. Let me tell you a little bit about why I'm here today. We at the Ethics Center started hearing stories and examples both in the media and with legislative staff and members about some of the ethical dilemmas that are arising with the proliferation of social media. We actually convened a group of legislative staff last summer to discuss it. We've written a bit about it, and we've actually been partnering with Megan Dorsch, who spoke 2 weeks ago, to a big group on social media training, and we sort of throw out ethical curveballs as you discuss how to use it in the legislative environment. Every time I read about this issue, it seems like somebody says that there's a blurring of the line between personal and professional, and every time that line gets blurred, I think that's a good place to have a discussion about ethics. Next slide. And so to that end, I thought I'd share with you a little bit of the findings from a survey that the Ethics Resource Center put out late last year. They do this survey every 2 years. It's called the National Business Ethics Survey. And last year, for the first time, as far as I'm aware, they had some findings about the use of social media. And it was about active social networkers, who they defined as those that spend 30% of the workday participating on social networking sites. Active social networkers, according to their study, account for just 11% of all workers who engage with social media. And by the way, we've talked a lot about Facebook and Twitter and a little bit about blogs, but now we've got Pinterest and Tumblr and Foursquare, and there's all kinds of, every day there's a new thing that seems like Facebook is buying anyway to use in our social media tool belt. So a few of the findings about these active social networkers. 42% of them said they felt it was acceptable to blog or tweet negatively about their company or coworkers, versus 6% of non-active social networkers. However, 56% also said that they would be likely to post about the good things that their coworkers did. So, a silver lining. They're more likely to use social media to talk about good things rather than bad. Active social networkers were much more likely than others to witness ethical violations while on the job. They were more likely to report misconduct, and they were also more likely to have received negative retaliation for reporting such transgressions, according to the survey. They also said that they were much more likely to experience pressure to compromise ethics standards. So why might this be? And I know there's quite a bit of percentage and information and text on the slide, so I'll try to talk slow. According to the study, these folks said they were much more likely to view their current jobs as temporary. 72% of active social networkers polled said that they plan to change employers within the next 5 years, and this is compared to 39% of non-active social networks. So maybe this feeling of transience leads to less company loyalty. Maybe it's not a big deal to take home software and use it on your personal computer, or to do less work to compensate for a pay cut if you know you're going to be headed out the door in a few short years. And so this is an interesting consideration for state legislatures. I think I've done some research and interviewing with staff who are under 35, and so what does that mean? How long are they going to stay, and what does that mean about what they're going to say online? The study found that they have a higher tolerance for certain activities that could be considered questionable, and they have different definitions of what is considered an ethical issue. In their summary findings, the center posed this question: regardless of company policy, employees are expressing a blurring of the lines, there's that term again, between personal and professional relationships, which could be risky. And as a result, will our ideas about what constitutes wrongful conduct change? ERC recommends companies develop ways to strengthen the ethics culture by using social networks or targeting active social networkers and using them as a key demographic, maybe to bounce ideas off of. And again, going back to the finding that they're actually more likely to post about good than bad. And they're actually doing an upcoming report on social networking in the workplace if this is of interest to any of you. So what guides how you guys in state legislatures are using it? Pam and John aptly covered some of the rules, laws, and policies that we see governing the use of social media. But again, there seems to be quite a bit of gray. And per Pam's, one of her slides, somewhere between 44 and 75% of companies have no formal policy. If you've ever been to one of our ethics trainings, you know that we talk quite a bit about values-based ethical decision-making. And the idea behind that is that you're using your values to kind of form a template over which you can put tough choices. And if I had time and we were all in a room together, we could have a good discussion about what values you bring to the workplace and how you define them. But since we don't, I will give you a cheat sheet. There are things like loyalty, honesty, integrity, trust, and respect. And values like these can all come into play when you need guidance on how to act in a situation where there aren't hard and fast rules. On the subject of tips, I found this from a group called the Federal Employment Law Training Group. They put out some suggestions when people lack guidance otherwise on how to deal with some of the dilemmas that are popping up using social media. But it's a lot of do's and don'ts. Don't access personal accounts at work. Don't access them on government equipment. Don't friend your subordinates. Be discreet in choosing a profile picture. Make sure you adjust your privacy appropriately. And then my favorite, if you've done something illegal or unethical, well, don't post about it. To that I say, well, maybe don't do anything illegal or unethical. So they got a lot of flack for this. They actually put this out on a social media site for government employees called GovLoop. I don't know how many of you are on there. It's a lot of, I think I saw they have over 30,000 members at this point, and GovLoop kind of hammered them on this stuff, saying, well, we have to use social media. It's a part of my job, and my manager's cool with it, so I don't see why it's a big deal to have it up at work. And the Federal Employment Law Training Group kind of backed off after all these comments came through, saying, well, yeah, maybe it's better handled on a case-by-case basis, depending on your manager. And they said what one person deems excessive, another might think is reasonable, and vice versa. Without guidelines, enforcement is nearly impossible. And I would say, well, yes, but if you apply some ethical decision-making to this medium, maybe you can find a happy medium. So together with my colleague Peggy Kearns, who's the director of the Ethics Center, we've come up with some suggestions, things to keep in the back of your mind based on some common values about how to operate in this medium. So one, protect the integrity of the institution. Be prudent. Be responsible for what you write. Respect and know your audience, and be authentic. And now I'll talk a little bit about each one. So on the integrity of the institution, John did a really nice job outlining what the laws are with respect to some of these issues. But as you also heard, some states are silent on these matters. And so I would offer up, when that's the case, think about the institution that you represent. We give the same advice when we're talking about conflicts of interest to legislators or staff. They're not wrong. They're the most common thing that pops up. But as a public official or an employee, you hold the public's trust. And there's an expectation that you're going to act accordingly, regardless of the medium. An example on this issue of integrity, when we did these roundtables last summer in San Antonio, in one state that we heard from, the IT office was struggling with the issue of subpoenas, as John sort of mentioned, and records retention. And they thought a lot, from what I heard this person saying, is they thought a lot about the integrity of the institution and protecting it. So they deemed that the institution was not going to be held responsible for legislature actions on social media sites if a subpoena was issued. In this state, they determined that the member would be custodian of his or her own records. And I feel like that they were using integrity to come up with this guidance. I think, as Pam's slide pointed out, there's many caucuses, more so than the legislature as an institution. There are caucuses using social media. And so there's interesting ethical dilemmas that we've heard about that come up as a result. If you're a member and you're in a closed caucus meeting, can you tweet about what's going on in there? And that actually happened in a state. And the person that did that did not get a lot of good feedback from their colleagues. I mean, I think there's a trust element there. Similarly, we heard a story about a staffer who was, tweeting, I believe it was a personal Twitter account, but tweeting kind of on behalf of the caucus, saying maybe some not so nice things about the other party. And so I think those are examples where you need to think about the institution that you're representing. Is it your caucus? Is it the leader's office? Is it the body? Is it the legislature? Next, be prudent. So picture this headline in your state. Party X demands apology for Party Y Nazi crack. The X party called on State Representative Z to apologize for his statements comparing Party X to Adolf Hitler this week and called on leaders to condemn the statement. So, of course, the press had a field day with this. It got picked up and retweeted. It was actually a misquote. The member who put the statement up on their Facebook page was not quoting accurately and tried to explain kind of what was going on by saying he was comparing the party that he was, calling Hitler to Nazis. I mean, I can't see anybody shaking their head or nodding their head, but I think maybe we can all agree that when it comes to social media, should keep away from maybe the Hitler references. And Google has a really long memory. This happened over a year ago, and when I was doing fact-checking about it and putting this person's name into Google, it was the 6th item down. So my suggestion, before you put something out there, stop, take a moment, and reflect on some of your values. Make sure what you're saying is in line with the principles you try to uphold. For some, it's honesty. For others, it's do no harm. I think you could consider the perception before you put something out there as well. And by design, this form of communication moves rapidly. As the Anthony Weiner issue pointed to, once you put something out there, it's hard to take it back. He tried to do that. He put out a tweet. He thought it was going person to person. It wasn't. He retracted it right away. And actually, the Twitter, I think Megan Dorsch might have covered this 2 weeks ago, but Twitter didn't even have the archived information anymore, but another entity, Tweet Congress, did, and that's where Andrew Breitbart got the information. Next, be responsible for what you write. So I'll give you a little case study about this issue that happened in the legislature. 2 years ago, the Ethics Committee in this legislature looked at something which the press was saying was the first time it had been a social media ethics complaint. And what happened was a member was tweeting during debate on the floor, and the tweets issued by this person suggested that fellow members were belittling their colleagues with rage and sarcasm. The members that this person was talking about were upset. They filed an ethics complaint, and it was sort of on that defamation issue, I think. The Ethics Committee recommended that an apology be issued. And so the tweeting member issued a formal apology, linked to the apology on Twitter, apologized in person, and then later, I think sometime later, deleted the Twitter account. Fast forward 2 years later, and the same legislature and a similar incident happened. Somebody was tweeting from the floor during debate, and this person's tweets mistakenly claimed that a colleague was making derogatory comments about a certain citizen group. In fact, the member who was speaking was actually reading from a report, and she got upset and filed an ethics complaint. The Ethics Committee ruled that the charges would be dropped if there was a written apology issued, same as their last ruling, basically, if that tweet got retracted and if on Twitter the tweeting member linked to the committee's decision. However, in this case, 2 years later, the tweeting member deleted the Twitter account first, then issued an apology, and then linked to the committee decision with the brand new Twitter account and 3 followers. Now, I don't know how many of you are active on Twitter, but what happens when you delete an account is that you wipe out all the followers that you had. And so in this case, the person apologized, but nobody saw it. So was the person abiding by the Ethics Committee decision? Yes. Was this person breaking laws? No, but maybe wasn't in the spirit of being responsible for what you write. So say it out loud, take time to think, and if you're going to disagree, be polite and appropriate. Megan Dorsch also has a great slide on issuing an apology. If you make a mistake, apologize, be respectful, do it as soon as you can, and say the words, "I'm sorry." Respect your audience and know who your friends are. Just quickly, I think John did a good job sort of highlighting this when he was talking about the issue of Sarah McCaskill. Do you really know who's following or friending you? And can you control what the media pick up? In Kentucky, the Secretary of State commented on the play of a UK basketball player after the Wildcats lost, and it made national news. He said, "I expressed an opinion as a fan, and I forgot that I'm Secretary of State." The incident was a good reminder that an official is always an official when he's making comments. It was a reminder that my opinions might matter a little bit more too, he said. So know who you might influence and what impact it's going to have on you as a public official, caucus, or office. Lastly, be authentic. I think there's an expectation when you're using social media that this is a legitimate dialogue between you and your representative, and it feels personal to people. So I think we should be honest about who is saying what. And here's some examples of public officials and NCSL's policy actually that kind of say who is actually doing the communication. So for the Michigan speaker, it's his press secretary. So coming out there and saying who's going to be actually issuing tweets, I think matters if it's not going to be that public official. And on the issue of authenticity, does anyone out there remember what happened to Newt Gingrich last summer? And this could also fit under the know your friends topic. He made national news when he claimed that he should be the nominee because he had the most Twitter followers. I think he claimed 1.3 million, and his aides told the media that it was because of his personal touch. He manages the Twitter feed himself, tweets all the time. And then two different groups did fact-checking and then claimed that at least 80% of those followers were fake and claimed that he was using social media companies, paying them to create accounts. And to my knowledge, that hasn't been disputed. So it's becoming easier to verify online authenticity or claims like you were hacked, like Congressman Weiner did. As Megan mentioned 2 weeks ago, people don't want you to use this as a bulletin board. They want it to be interactive. So be aware of some of the benefits and pitfalls that come along with that issue of authenticity. And if you're just turning away from YouTube now and have missed the entire presentation, I give you this as an if all else fails guide to posting on social media sites. Again, trying to be funny, but I think the key is, would it be awkward to explain to your boss or your parents? If so, don't post it. And if you could take away one thing from my comments, it would be that it's not the medium that matters, it's the message. Thank you.
Thank you, Pam, John, and Natalie, for that overview. Now we will get to your questions. And we've got a couple that are kind of related here in terms of negative comments that are posted on sites. Let me kind of pose both questions here and then probably toss it to John to first respond. If there are several negative comments posted on your caucus or legislative office or boss's Facebook page, should you delete those comments? And then a related question, what if someone tweets something inflammatory, even using appropriate language when tweeting about an elected official? John, what's your reaction to that?
Well, I think it's risky to do that. I think you definitely need to consult with an attorney in your jurisdiction. And the reason why is because I believe that the limited public forum theory of the First Amendment law applies in this fact pattern here. And what usually that means is that you adopt a set of policies, and they in those policies you establish time, place, and manner restrictions about how you're going to address issues. If you're engaging in personal attacks, or you're not talking about something on message, or just talking too long about something, and these are all coming from public meeting type scenarios there, where you have to be able to control what people are saying in a meeting, because people want to go home before 4 o'clock in the morning, ideally, and we're actually talking about, we're trying to accomplish a specific goal in the meeting of whatever deliberative body that we're talking about here. And I don't think that's necessarily the wrong analysis there, but the problem is when you're on a social media account and you're on, say, Facebook or posting on the web on discussing something on a blog that might be created by a state governmental entity, well, if somebody doesn't like what somebody's saying, or somebody's offended by some obscene comment that got posted, well, they can just skip over it, or they can collapse it in a lot of cases, so they don't have to look at it anymore. People have a lot more control over how they interact with social media than they do, say, when they're in a meeting or they're trying to eat lunch in a park or something like that. So I have to say that if you are if you're providing a public forum for people to discuss things, and you are doing that using a government account or on government time, it's very risky to delete or alter in any way the postings that somebody might put on there, and you really want to talk to an attorney and discuss what you want to do and what type of policies you want to adopt before you engage in that type of behavior.
Okay, thank you, John. The next one is for Pam. Pam mentioned that there are tools available to deal with address records retention issues relating to social media use. Will a few of these tools be identified at a later time, Pam?
Yeah, well, I think a couple of things here is, one, if you have the same information on your social media site that is available elsewhere, then that kind of information you don't need to worry about. But that said, there are a number of tools. I mentioned Facebook has a timeline, which apparently you can retrieve your past postings now from Facebook. But as John mentioned, there's no guarantee that you'll be able to do that, when you need to. There are some other kinds of tools and software that I'm not familiar with using, and so I'm not particularly, endorsing. But things like TweetTake and Twinbox and Backupify. And I think there's a Firefox browser plugin that you can use to retain some social media records. You might talk to with your IT staff, things that, I'd heard of one government organization that created a database and stored all the videos that they posted to their YouTube site. So there are a number of different ways of dealing with that.
Okay, thank you, Pam. This next one I'll direct to Natalie. This is an interesting question. Should we at least establish social media accounts so individuals outside of our organization cannot pose as us or be confused with us?
I think this is a terrific question, and I don't know that I have an answer to it, but I would let the person asking it know that this has been an issue, and I think some legislatures, too anecdotally that I know about, have dealt with this, where a faux Facebook page was set up for the legislature. In fact, NCSL had this problem too, and it was a real battle, according to the folks in our public affairs department, to try to mitigate that, figure out, how to, hearing back from Facebook. I think even Salman Rushdie had this problem where he couldn't register for Facebook under his true name, and so the issue of authenticity and Pam is pointing to some. Oh, gotcha. Sorry. I think it's a really good question. I think it's something that legislatures are struggling with. So I don't know that I have an answer, but I think it's something to think about and know that it has happened.
Okay. Well, this next question I'll kind of throw out to the group. Is it okay to watch other people's tweets that are being written about the elected official that you work for? Is it okay to monitor?
Pam and I are nodding our heads. I think maybe I've never worked as a communication staffer in a legislature, but my guess is that might be part of the job in some places. So, I think getting knowledge seems okay to me. John, any thoughts?
Yeah, I think so. You might want to consider whether you're watching those tweets as a legislative employee or as an employee of the campaign. But yeah, I think that just knowing what people are saying about your boss I think that's a fundamental part of being an employee of a legislator.
Okay, and this one I think might be a legal question, John, so I'll kind of direct your way.
Okay.
How much does a disclaimer, such as, quote, all tweets are my own, does that protect you from liability?
Well, I mean, it depends on what you're saying as far as liability goes. As far as saying that all tweets are my own, well, you might be able to, if you embarrass your employer in some way with the tweet, you can, I guess, go back to your boss and say, well, you see how I said that all tweets are my own, so it really shouldn't reflect on you. There's a complex set of laws associated with what types of rights a government employee has with regard to the First Amendment than a private employee does. Government employees are slightly more protected with regard to what they say. If you're talking about issues of a public concern, there may or may not be some protections for you depending on what you were saying and when you were saying it and how you said it. But no, I honestly, I wouldn't. I'd say that it's useful as far as your relationship with your boss, and potentially explaining to people who are following you that you're saying something that your boss may or may not endorse. But you know, the fact is that if you were employed by that person is therefore at least at some level endorsing you. And if you say something that is bad enough, or that they really have a hard time having people know that you said those things and still working for you or for them, you've got a problem.
Okay, thanks, John. This next question is: what are your recommendations about allowing legislators to connect their Facebook or Twitter accounts to their page on a state legislative website, knowing that their social media account includes campaign, legislative, and personal information? Natalie or Pam, do you have a response to that?
Well, I can tell you that there are a number of states that prohibit links on the official legislative site to an individual legislator's own personal website. And the few that do allow it, they usually have a disclaimer that will pop up as soon as you click on the link. It will tell you that you're leaving the official website and heading to a different one that they don't have responsibility or control over. Natalie?
Yeah, I think that's good, Pam. I think maybe one thing to consider, and I think I've heard this from a legislative office before, is that those pages on the legislature's website, I mean, the legislator is a representative, so they're from District 1. And so, that's actually information kind of tied to that aspect, I think, of their public service. So, linking to their personal information, to me, I could see how this could become a do or don't, depending on the policy. States have definitely run into ethical problems, like commingling, as John mentioned, with respect to campaigns and keeping them out of the legislative sphere. One suggestion or thing to consider if you're a member is to, it's a lot of work, but Governor Deval Patrick has like 4 or 5 different Facebook pages, one for himself as the governor, one for himself as the candidate, one for himself as the person, and I can't even remember what the other is for now. So, that's, if you really, are concerned, I think that's a tip for your boss or if you're an elected official.
Okay, thanks, Pam and Natalie. John, let me direct this one to you. What legal exposure does a legislature or legislator have from the people who are active on an official or semi-official legislative social media site? What would be the impact of the recently approved federal cybersecurity legislation have on this whole issue?
I don't know. I think you have a number of different liability issues there. For example, let's say you allow somebody to post copyrighted material onto the website, and you've been notified that you need to take that off. There's certainly copyright liability. Anytime that you're hosting anything, any sort of public forum where people have the opportunity to bring and share whatever they want on that public forum, to some extent you're going to be responsible for what they say. So I think really what you have to ask yourself is specifically what is your concern, what is the issue that you're worried about, and then talk to an attorney in your jurisdiction, because the answer might vary depending on where you are.
Okay, thank you. This one talks about we talked about employer issues earlier. And this question is, does an employer who does not search social media sites before hiring an employee risk later being held liable for negligent hiring if the employee later causes harm? Is anyone here had any experience with that or heard any anecdotes about that?
I think it's going to depend on the jurisdiction. But again, if your policy is simply not to look at these things, and there's no reason, the issue here generally for the tort of hiring somebody when you knew that you shouldn't hire them in that type of situation, you usually have to know something about that, and if you don't know anything, if you don't seek out that information other than what your interaction that you have with the applicant, and just generally knowing about their you check their references and things like that, you're not going to generally have that kind of a problem. But if you go and seek it out on that Facebook account, let's say you seek it out on the Facebook account and you don't look far enough, you don't look at every single photograph or you don't check every single posting, under that logic you're going to have the same sort of issue there. So I think that based on the very clear and direct liability that you engage in as far as identifying some sort of or somebody identifying a protected class that they belong to, and then you making a employment decision not necessarily based on that protected class, and them turning around and having trying to assert some sort of legal right with regard to that. I think that's much more risky than not knowing something and telling somebody that you didn't know it, and then having somebody try and assert a legal right based on that.
Okay, thanks, John. Natalie, you recommended to be authentic with social media, but is that really any different than a communications director who submits an op-ed under his or her boss's name?
Great question, and I think that speaks to the point I made at the very end about it being the message and not the medium. I remember interning for a mayor's office when I was in college and showing up my second day there and getting asked to respond to constituent letters and seeing a desk where there was a pen poised to, when you pushed a pedal, signed the mayor's name, and I felt so disillusioned. So I agree, it kind of feels similar. But I will add that I think on using social media, and I could be off, but to me it feels more personal. I think people who are using it feel like they really know something about you if they're a friend. We can debate what it really means to be a Facebook friend for a long time, but I do think there's an expectation of real dialogue and quick responses, and so that's kind of where I was going with the be authentic. But good point.
Okay, Natalie. Let us close on this question. I'd like to hear the panelists' thoughts on allowing nonpartisan state-employed staff to post to social media on behalf of the legislator.
John?
Oh. We going into that legislative advertising situation that we have here in Texas, I think there's possibly a problem, or at least you need to have a disclosure announcement there in the if you're going to do that here in Texas. That's what I would counsel somebody if they were doing it here. I don't necessarily see a problem with that, but again, and I know I've said this about 20 times, but you should talk to an attorney in your jurisdiction because there might be limitations on that type of behavior there.
Okay, thanks, John. Okay, we're going to close things out now. Our panelists have some resources that you may want to be aware of, and actually when you get the PowerPoint slides here, these links will be active and you'll be able to get that information. So let me start with Pam with your resources and any final thoughts.
Okay, well, we had a couple of questions about resources or good policies, and the Center for Technology and Government has some guidelines for developing social media policy. It includes examples, and it's a good resource. I mentioned earlier the National Labor Relations Board report. It's not a ruling or an order, but it does give some examples, again, of things to avoid and think about. Someone also asked about where our pages are that list social media sites. Again, to type go space 13409, that will bring up a list of legislative social media sites, the ones that we're aware of. Send in any others that we missed. And someone had asked, do we have a list of all the legislators' sites or Twitter accounts or that kind of thing, Facebook pages? That's very difficult to track, although I know Megan Dorsch does have some Twitter groups with legislators listed. But it's getting harder and harder to track all of the different social media policies that the caucuses and nonpartisan sites are using, and almost impossible to track legislators' sites. The last web page I'll give you again is some examples of policies that legislatures have put in place or other organizations. Type go space 18215 in that search box on the NCSL homepage.
Okay, thank you, Pam. And Pam's email address is there at the bottom of the screen in case you needed any clarification or more information on any of these resources. Natalie, your resources and final thoughts.
Thanks, Jean. Yeah, I just included some links for you guys. This Ethics in a Virtual World and blog, tweet, and post Proceed with Caution both appeared in one of last year's issues of State Legislatures magazine. I'm happy to send that to anyone directly, but those are the links if you'd like to read through. I wrote one, and it's basically a recap of our little group that we convened in San Antonio, and Judy Nadler, who works for the Markula Center for Ethics at the University of Santa Clara, wrote the other, and she has a really great blog and kind of talks about some of these issues. And as I mentioned, we in our ethics training, increasingly we are bringing up social media conundrums, and our scenarios are often based on experiences that you all have had as staff and members. So, if you feel comfortable sharing those, we'd love to hear about some of the issues and questions that you're running, issues you're running into and questions you have. So feel free to contact me.
Thank you, Natalie. And again, her email address is at the bottom of this slide as well. And John, final thoughts?
Oh, well, I just wanted to thank NCSL for the opportunity. I hope everyone found this to be useful. And if anybody tells you differently from what I told you today, then they're almost certainly correct.
Thank you, John. And you might explain what that image is up on the screen.
Oh, that's a QR code. If you want to load my contact information into your smartphone, you can take a photograph of that with the appropriate software, and it'll show up in your contacts page.
Okay, thank you. And thank everyone for joining us today. As a reminder, you can keep track of all NCSL webinars by going to www.ncsl.org/NCSLU. Our next webinar in the NCSL University series will be held on May 11th. Negotiations expert Dr. David Landis will lead us in a webinar called Becoming an Effective Negotiator. Also, earlier that day, we'll have a report on the fiscal health of states, citing fresh data from a new NCSL survey that will be distributed soon. Registration information for that webinar will be made available early next week. So thanks to you and the Legislative Staff Coordinating Committee for support for today's webinar. On behalf of NCSL, this is Gene Rose. We look forward to being with you again soon. Thank you.